Founder and Deputy Director of IDLOC, the International Drug Law Advocacy and Resource Center. We're a small NGO based out of New York City. Before I start today's panel, I'd like to acknowledge the Musica groups, the First Nations custodians and the rightful owners of the land which we meet on today. I'd like to acknowledge their wisdom, their leadership, both past, present, and future. I'd also like to say that land back and country acknowledgements are not enough. We need reparations, justice, for all Indigenous peoples, both here in Bogotá and across the globe. I'm super excited to present this panel today. I was part of the conference programming committee that put this panel together, and I'm kind of very honored to chair. So I'd like to introduce our first speaker, and apologies if I butcher your last name. Our first speaker is Céline Debaulieu, and Céline has almost 30 years experience in organizing with harm reduction programs, developing new projects with drug users in Paris and internationally. She's built projects and established initiatives in Serbia, Tanzania, and Burma, and also coordinated the opening of a drug consumption room in Paris in 2016. I hand the floor to Céline. Thank you.
Thank you, Benjamin. Thanks. Okay. Let's wait the end of my presentation. Who knows what will happen? No, I'm very happy to be here with you and to present a very recent, actually, litigation. At the time where we wrote the abstract, it was we were planning, and it was already in a process of being launched. But it was really launched. I will explain the process. But in April, I mean, obviously not early April, but and it's something new for Médecins du Monde to do it in harm reduction, because we have experience to do litigation, especially for housing, for migrants. We have, and for climate also. We were doing several, but for harm reduction, it's very new. I don't know, maybe we got inspired by Canadian because our colleagues were also doing that, and we have very well-known organization, PWID, that we are close to, and which is doing that, and it's many years that we are thinking about this, and it was a long process, actually. Okay, just very quickly to say a few words about Médecins du Monde, so Doctors of the World. We have a very long experience in harm reduction, and I would say, I put it like this because it's one of our main battles inside the organization. Because we started when nobody wanted to start anything in France, late 80s, and together with another organization named ED, we were the first one to start when it was illegal, needle exchange program, and after OAT, and we disseminated projects all over France. And mid-90s, we started also, because Médecins du Monde is a non-governmental organization, so we have projects abroad at international level. So we started also to implement harm reduction at international level. So in many, many countries that some now are not, the projects have closed after some years, but we started in Burma, then very quickly after in Russia, and Serbia, China, Vietnam, Afghanistan. We have really a full range of a number of countries where we invested in harm reduction. I would say why? Because we wanted also to have the possibility to operate in a country, to be really on the ground, to see what we could do, what we could achieve, and then being advocate. Because we don't conceive to do advocacy if we don't know what we do, if we don't know the subject. So it was really important to have this connection with the field and with the difficulties, and it was happening. So we introduced harm reduction also in many countries. That said, sorry, I'm very bad technically speaking, and as you can see it. And today, we in France, because we had a law in 2004 that made the harm reduction legal and institutionalized, all the projects were handed over to I would say local organization, but on organization. So they both created and were created from the existing staff and project. And so little by little, Médecins du Monde was not operating anymore in France. But we really stayed nearby because we have close relation with, of course, those organizations, and we wanted to remain an advocate. So because we have this connection, we have information about the ground and the field, and then we can be advocates and we can have a strong political position and regarding, especially drug policies. So we are still, we were still looking what is happening in France and monitoring the situation. So about the litigation and the legal action that we launch, first a little context, because it's based on what is happening about drug consumption room in France. So we have 2 drug consumption rooms in France since 2016 that we managed to open after almost 10 years of battle also to get those 2. It was not limited to 2, but it ended up like it has been only 2. Because actually what we have seen over the years, so after 2016, some other cities wanted to open drug consumption room, and at sometimes the last moment, or sometimes a little before, all the time the state intervened and said, oh no, it's not the good location, oh no, we don't agree. So in fact, they were really making obstacles to open new ones. So, and we have also something to take into consideration. It's like those drug consumption rooms open under experimental agreement. So, and at the beginning, it was from 2016 until 2022. In 2021, because nobody wanted really to decide anything, it has been decided that the experimentation was extended, so until the end of this year, until end of December this year. So this experimental status makes them very fragile, and because nobody knows what can happen. And so the main thing was to say, okay, at one point, when will they decide to make it sustainable? Because this year, it's 9 years that it's operating, so it's quite long. And as I wrote, we had several researches, we had studies, and even the last evaluation that was made about the drug consumption room was requested by the states. Our Minister of Home Affairs, actually, last year, asked what we have internal administration to evaluate. And their report is so good that we said, like, we couldn't even write it better, because it's like requesting sustainability of the drug consumption room, requesting opening of new ones. I mean, it's just brilliant. So the actual government didn't want to make it come out, but it did. So we all have it, and we can use it also. Our lawyers can use it. So we have all the, I mean, if we have all the proofs, we have everything. We can see the benefits that it brings to the drug user, of course, but not only to the neighborhood, to public space. So we have the evidence, and nothing is moving. And I will not talk about the government and French government at the moment, but it's critical, as in many other places. And of course, extreme right is also taking more power. So we have this. So we have this context and climate that make it like we launch 2 litigation. So the first one, and we were also, national organization, Fédération Addiction also joined this first legal action. It's like we requesting actually the states finally to decide the sustainability of drug consumption room and to put something to have a legal, clear and sustainable agreement about the existence of the drug consumption room. The objective is really to make them sustainable and to have really a clear decision. And the second one is focused on a city in the south of France, Marseille. We tried to open a bit more than a year ago a drug consumption room, and they were also very close to open one, and it has been stopped in a moment where nothing was really clearly said, but they were close to it. It was mostly almost approved by the Ministry of Health. Then at that time the minister resigned, then no more Minister of Health. And then some politicians and opponents then had time to organize and to say, no, we are against, we don't want, and to mobilize also people on the ground. When I say people, I mean sometimes neighbors nearby, where the place were supposed to open. And then finally, the municipality said, oh, maybe not, we will not. So it's ended up a bit like this, with no really clear decision. And it's more than a year that they are like, okay, what is happening with us, So they are a very strong organization working together in Marseille. I think it's very interesting to see because we don't work everywhere in France the same. And so, yeah, they are very strong and they want to move together. And they were saying, like, really expressing, like, okay, now we have nothing to lose. Let's do this litigation, because the objective of this second litigation and to ask the state to reopen actually the Marseille case, I would call it like this, as a project, and to really provide practical support for the opening of the drug consumption room in Marseille. So it's what we decided to launch. So when I say that, it took 2 years, for us to figure out, and with the lawyers, because I'm not a lawyer myself, but I have a colleague who is a lawyer at Médecins du Monde, and he really tried to figure out how to make it, and we work with a lawyer firm, because we cannot go on court, even we need to be to have real lawyers working with us. So we had a lot of discussion and exchange, so it took 2 years to arrive like, okay, we have a solid case. If the lawyer was there, he would say that we have 40 pages of evidence and proofs that were sent. So it's a strong case. And so we decided to launch it. So, oh my God. I'm sorry. So the 2 legal actions were launched, so really April 15, and for that, prior to that, we also organized, because we said, okay, it's the occasion that we have also the communication we want to have about drug consumption room, and so we prepared press release. If some of you read French, I have two. Sorry. And we really prepared to have a press conference where we invited journalists, so it was 10 of them, and we had a panel of representatives. Okay, it was like a bit casual in a cafe, but still we were a number of us, with, of course, representative of Médecins du Monde and Fédération Addiction, but also the DCR operating in Paris and Strasbourg, because they are the 2 cities operating drug consumption room in France. We have the representative of our lawyer firm and of a neighbor also from the Paris DCR, who came to say, okay, because he lives there since a very long time, and he was really expressing what actually the DCR brought to the neighborhood in a positive way. And we had also a representative of drug user, somebody who knew the scene when it was, even at the time, even the mobile unit of Médecins du Monde, so even long time ago, during late 80s and 90s. And so he saw all the process of the neighborhood and how it evolved, and he wanted to testify of that. And he's also working in the drug consumption room, so I think it was interesting to say that drug user can do many things, as we all know. So this is a little, okay, so it's a lot of French. It's a French class, very quickly. No, but it was just to say that from this press time and conference, we had very good, and my colleague from the communication department told me, okay, this is the first time that we have the number of journalists that are supposed to come that are really coming, and we spent with them almost 2 hours and a half, so it said nobody usually is staying that long for any press conference. So we could see that we have a strong interest, and after, we had more than 110 articles and radio, TV reports. So, and I put it like this because mostly what is said is like what the journalists express. It like we are launching a litigation, that we are suing the state, and because the state doesn't provide the normal access for drug user to access health and social rights, So it was really this that was expressed, so quite very positive. We can also was visible to say that from after 9 years, we see that it's moving, the perception and the opinion of drug consumption room from journalists, but from general and public opinion. So we can say that it was, for us, really successful to have this, and really few. We had maybe 2-3 articles that visibly are written by people from right or extreme right, and that are very, strong opponent, but nothing surprising from those newspapers. And in Marseille, they also did organize a press conference themselves to launch the litigation, and they also had numerous interviews and articles, and they could express, also what they were. Where they were in the middle of nowhere, actually, in the no man's land, with the drug consumption room, that nobody is moving and nothing is done. And I could say some interesting result that came out very quickly, actually even the day after or the same day that we were launching the litigation, is that another city in France that were very close to open contacted us and said, okay, we saw that in the newspaper. We want to be part of it, because us, we almost open, and now it's 4 years. We are like nowhere, and the municipality is really supportive. So we said, okay, we didn't expect that, but it's really interesting. So we are working on it to see how they can join, actually, the litigation. We also received a letter from the Ministry of Health, the lawyers. When I say we, all of this is going, except the contact with the municipality, but with the lawyers. But the letter from the Ministry of Health is kind of vague, and also targeting the local authorities to say, it's not really us, we are okay, but it's, at the municipal level and at the city level that it must be decided. So we'll see what we will do with that. And it was at the same time because, of course, you can imagine that we are doing the litigation, but before that we and actually the organization, Gaia and ITAC, operating the drug consumption room, are contacting since months a member of parliament and a politician to explain that they need to sustain the drug consumption room. A lot of work has been done. So at the same time, a member of parliament just proposed a law to sustain DCR, but this proposal is inter-party, so it must be some number of signatures for this to be discussed at the parliament. So it's like the clock is ticking, I would say. So it's we have really few weeks, even days, to have this sufficient number of signatures to this law to be law proposition to be discussed at the parliament, and maybe to have the chance to be voted, of course, before the 31st of December 2025. That would be a bit complicated. And I guess I'm okay. I can have my leg. Okay, I'm in time. Beautiful. I wanted to end with why legal action, because it's also something that people ask us, and again, I said it's not something that we do, but we learn. Some colleagues in other countries are using, and I have several colleagues at MDM who are lawyers, and we are really like, okay, it's very interesting to do a litigation, because then also you can have access to the arguments of the other side, but and also because you oblige them to answer something and to say something, because at some point you will be in court, it will be a judge, and it will be a hearing. You will have to say something, and before that you will need to send some proof also. I said we have our 40 pages of written proofs and statement. So we said, and then you also know what they will say, and we'll see, and this is also very important. Also, I think it's very important because we decide also the moment and what we say about drug consumption room and harm reduction. And we are not on the defensive and obliged to answer to the opponents. Because usually it's very often like this, we are attacked, we are answering, we are attacked. And so we are all the time, and when you do a litigation, you decide. It's you. You set the scene, You said, okay, that day we will talk about this, and we will talk about this that way. Then you do your press release, and you do, It's like you decide you have the control of this, and you are a bit more offensive, and not defensive. And I think for a lot of harm reduction activists, workers, it speaks, like we are like, okay, yes, we want to have this space, to say exactly what we want and the way we want to express it. So the narrative, we are deciding what we say. I would say that it's also important because to have this approach, it also gives the opportunity to say that the state has a responsibility and that you put the state in front of its responsibilities, and that's also a really big level. In terms of advocacy, you are like, okay, you cannot just avoid or, just like, no, it's not me or it's somebody else, but you really ask them to say something. And so it's really interesting and really important tool in terms of advocacy. Of course, you need to have lawyers committed to that. We have the chance to have them. They are super excited to do that, and they were so happy to do this together. And also, before that, I would say we published, together with the organization Gaia, who is running the drug consumption room in Paris, a comics about the drug consumption room. So it's here. I have two also. It's in French. I'm really sorry. You need to be fluent in French today. But it was really the objective was, we want to talk about the phantasm. The fantasy. All the representation people have about drug consumption room and harm reduction. And then we want something that can be useful, to think about this, but clearly, and also to be easy to be read, and okay, I'm really almost done. This was my last thing about the comics. But then it's good because many people said about this comics that finally they understood what we are doing in harm reduction, what we do in the drug consumption room, and then it's supporting what you are doing. It's not only that, but it's to have several tools that which really also help you to explain, and for people to understand, and maybe not to be only on, this is something very weird that we don't get, and we need to be against the drugs and the drug user. So that's something also that I think is supporting the legal action in a way that we need to think about. And yes, thanks. I have my colleagues to remind me that if you want to read the first chapter in English, it's downstairs where you have, all the board and the exhibition. So please, that's and maybe it will be translated in English, but I don't know when. Thank you very much.
Thank you very much, Céline. I think that's so important to kind of control the narrative around harm reduction. This is something that's, often we're so on the defense. And, it seems like a common theme is with drug consumption rooms that the state often puts it into an experimental or a pilot stage and kind of, waves this carrot in front of us for a long time. And this is such a great example of how we can push back and build communities and change hearts and minds around harm reduction. I've just got some quick housekeeping before we move to our second speaker. Sergio, our final speaker for the day, is actually going to be speaking in Spanish. So those of you that don't speak Spanish, we don't have actually human translation in this room, but you do have the Wordly app. And if you turn to the page, if you haven't downloaded already, it's on page 30 of the booklet, and there's a QR code in there, and you can just link to it, and it's AI translation. So thank you. I'm going to move on to our second speaker now. Our second speaker is Niamh Eastwood. Niamh is the Executive Director of Release, the UK Centre of Expertise on Drugs and Drug Laws. She co-authors Release's policy papers and advises governments on drug policy and decriminalisation. Niamh is a visiting professor at Manchester Metropolitan University and has written reports for the Global Commission on Drug Policy. Thank you very much.
Thank you, Benji. And thank you for that amazing presentation, Céline. That was brilliant. And I think it really kind of sits with what I want to explore in this presentation about the idea of legal empowerment, not just at a strategic litigation level, but also how we do this locally and how we mobilize people to support, to challenge policies, orders, procedures that are targeting people who are the most vulnerable and the most likely to be on the margins of society. So a little bit about Release first. Release is, as Benji said, the UK's Centre for Expertise on Drugs and Drug Laws. That's the elevator pitch. What we do is we provide legal services in the community to people who use drugs, particularly those who are drug dependent and who are experiencing marginalization because of the intersection of their drug use with deprivation. And I think this speaks to how our drug laws are often operating in a classist and racist manner. And again, I'll pick up on that in the sort of area of work that I'm exploring here today. So we provide legal services in the community. We also advocate for people's rights and treatment to make sure that they are getting the treatment that they are entitled to and they deserve. And from the experiences of our clients, we do policy work. So our policy work is largely grounded in harm reduction responses, in evidencing the harms of drug law enforcement, not just in the UK, but in the international sphere as well. And then looking at solutions, things like decriminalisation. So we've done a lot of work mapping decriminalisation across the world, and that's available on our website. It is also available on our second website, which is Talking Drugs, which is a multimedia website that does updates regularly on drug policy and harm reduction developments. And we have a beautiful interactive map that shows all the jurisdictions across the world that have ended criminal sanctions for possession, at least possession of drugs. And I think this speaks very much to the idea of decriminalisation often focuses on the conversation around removal of criminal sanctions, but as we've seen in the context of Oregon and in Vancouver, for example, the use of bylaws and the use of civil laws to control behaviour too, and how we must be alive to that. So bear with me on this one because it's a new piece of work. It's very early days, but I wanted to share it with you all and get feedback really on how we can develop this, improve this, make sure we can make change for the better. I'm going to take you on a potted history of the UK's shameful use of antisocial behaviour orders, or ASBOs, introduced in the late 90s by the then Prime Minister and his government, Labour government, so that was Tony Blair, who largely got elected by shifting to the centre-right and talking about being tough on the crime and the causes of crime. I always think it's ironic that he takes the stance at the same time that he's introducing the Human Rights Act. And I'll explain why I think that's ironic when you see what was brought in. So the beginnings of ASBOs, the early days, and I am old enough and long enough in this game to remember the introduction of the 2001 Criminal Justice and Police Act. And it introduced something called crack house closure orders. And that is what the legislation describes it as. And so these were orders that could be applied for by police forces, where they believed that there was Class A drug use on a premises and that there was nuisance behaviour. When we talk about premises, this could be nightclubs and things like that, but it was in terms of residential accommodation only applicable to social housing. So only applicable to people who were tenants of a local authority. And so this intersection of drug policy and targeting people who live in deprivation. And just quickly on the process of a closure order, which horrified me at the time as a young legal advisor, supporting people who use drugs, and them coming in with the notices that they had received. So they would receive a closure notice. A closure notice would be put on the premises by the police, and it would say, your premises has been identified as being one where there's Class A drug use, nuisance behaviour, and you have 48 hours to get to the court before an order is put in place. 48 hours. I don't even think most of us, with all of the resources that we may have, could organise getting a lawyer. And the confusion here was because it was a civil order, but it was being heard in a criminal court, was like, where do you get legal aid from? So even navigating this was a nightmare for everybody, including legal advisors. I had to convince legal aid firms, criminal legal aid firms, that they could get legal aid for this. So in 48 hours, it would get to the court, and then the premises more often than not would be shut, and it was shut for 3 to 6 months. And that person, their family, anyone occupying the premises had to leave the premises, and if they returned, it was a criminal offence. They could be sent to prison. They could return on the expiration of the closure order, but more often than not, the local authority in tandem would apply for an eviction order. So that was 2001. 2005, we see it moving to brothels. So we have the Sexual Offences Act of 2005 comes in, and they're like, okay, we're going to use this for sex workers because, you know, drug use, sex work, it's all bad. And so they went after sex workers as well. And we were very involved with sex worker movement in the UK to try and challenge this. And by 2009, it was any nuisance behaviour. So it didn't have to involve sex work, although those powers still remained, didn't have to involve sex work or drug use, but any nuisance behaviour. And thinking about social housing, this was all about targeting people who were living in deprivation. Okay. So going back to that, you know, sort of divergence of like, ASBOs, toughen the causes of crime, civil orders, removing people's social and economic rights, and at the same time bringing in the Human Rights Act. And this boils down to whose human rights, who is protected in the system. And we know clearly that the classist and racist nature of drug prohibition and the associated civil laws that are used to tackle drugs, or to tackle people who use, or address people who use drugs, is not about their human rights. So by 2010, there were 19 different types of ASBOs. So I'm not going to go through them all, but you can see right in the center is those premises ASBOs that I described, but also things like graffiti removal notices, which, you know, Bogotá would have been wrecked by that. It would be devastating to us. So, you know, just trying to control behaviors through very easily obtained civil orders. The coalition government comes in 2010. They're like, we don't want to do ASBOs. We don't want to do ASBOs. It's all too complex. You know, we need to simplify it and streamline this system. And so they bring in the Antisocial Behaviour, Crime and Policing Act. And the then Home Secretary, who became our Prime Minister at a later date, said it wasn't an ASBO anymore, it was a civil power. But what they really did was they collapsed those 19 orders on the previous slide into these 6 orders. Yeah. So the closure of premises orders now held the crack house, closure orders, the brothel closure orders, and the nuisance closure orders. The injunctions would go for things like a graffiti and littering, things like that. Community protection orders were littering. I want to talk about the Public Spaces Protection Order. So this is the specific piece of work that we are looking at the minute. And so this is my busiest slide, and I'm sorry because it's the law and it's miserable, and drafting legislation must be the worst job in the world. Possibly not, but it's a pretty bad, reading it is harder. So Public Spaces Protection Order says that the local authority can make a PSPO on the following conditions. Activities occurring in the local area are having a detrimental effect on the quality of life of those in the locality, or it is likely that activities will have such effect. So this doesn't even have to be happening. They can still apply for it. And the effect, or the likely effect of the activities is, or is likely to be, persistent, unreasonable, and the application for the PSPO is justified. The duration of a PSPO can last for 3 years, but then it can be extended for a further 3 years. A breach of it is simply a street fine, but considering who is targeted under these, people can't pay fines. And so it's £100 to be paid in 14 days, non-payment results in prosecution, a fine of £1,000 and criminal conviction. And I'm sorry about the spelling, they said they would fix that for me. So PSPOs didn't really come onto our radar at all after it was brought in 2014. And the first I was approached about it was in 2023, when this gentleman, who you can see, Arvin Jones, who was he had just retired. He had been the Police and Crime Commissioner for North Wales. And the Police and Crime Commissioner is an elected position in the UK, and they are responsible for local policing policy. And Arvin actually, I'm an abolitionist, but as a PCP, a police and crime commissioner, he was very much a drug reformist. He felt that the drug laws had failed. He was part of a lot of conversations that had been happening throughout the 10s to challenge drug prohibition. And he emailed me, as I said, he was retired, and he said, Niamh, you'll never believe it. Wrexham, they've got this thing called a PSPO. And they're consulting on it, but it's been in place since 2020. So this was the point that we'd had 3 years of it, and they were going for a renewal. And there's a duty to consult both at the initial point, but also at the renewal point. And I was like, well, we haven't really done any of this work before. Tell me more, what's going on? And it was specifically in Wrexham. And if any of you have Disney and Ryan Reynolds, he owns the football team in Wrexham, so this is what's going on at the same time. And they had put in place a PSPO that had a number of conditions, but one of the conditions was that you weren't allowed to carry drug-injecting equipment, or drug-using equipment. And that, the area it was applied to was the area where the harm reduction service was. So whilst the possession of injecting equipment is legal in the UK, not all paraphernalia is legal in the UK, but whilst injecting equipment is illegal, this PSPO would have put people at risk of the civil order. And at that time, thankfully, we had friends in the Welsh Government and in Public Health Wales, and we went to them and we said, have you seen this? And they were like, no. And they worked with us to make sure that Wrexham didn't bring this in. But it was a start of our journey into this space. And again, just a little bit later in the year, we were then approached by the Green Party councillors. So that's the local municipal politicians, councillors, from Lewisham Council. And we had just had a local election maybe the year before, and the Greens had done really well. And they were outraged that the executive part of the council were proposing to bring in a PSPO that would have targeted anyone who was, without reasonable excuse, erecting a tent, and it was particularly targeted at tents, or another structure on public land that was owned or managed by the local authority. So that was the first thing that they were targeting. And, this goes back to my point about Oregon and the kind of enmeshment of civil and criminal. And we saw the attacks on Oregon being around public drug use, which wasn't about public drug use. It was about an explosion in homelessness that has occurred across many countries since the pandemic, since, the late 10s and during 2020-21. And in fact, we just did some work with the Global Commission, and I just want to pull up some of the stats on homelessness, which I've lost. But basically, so for example, in the UK, homelessness increased by 45% between 2020 and 2023. In France, it's 110%. Like, it's extraordinary. So this is a crisis everywhere. But rather than dealing with the social and economic underpinnings of that crisis, what they do is the easy route, start to disperse people. So this was one of the conditions. The other one was that you were prohibited from being in an area in possession of drugs, even though possession of drugs was illegal under the Misuse of Drugs Act. So this is kind of a double approach that they were taking. So we, with the Greens, went and wrote because they were duty to consult, they were consulting, we wrote a submission outlining that the targeting of possession, in addition to the criminal law, was a ridiculous legal approach, but also it would likely increase stop and search of young black people in the area of Lewisham. And we do a lot of work evidencing racial disparities in stop and search. So we were saying this could be a problem. Also, that the fact that they were targeting people who were unhoused was just unconscionable, and actually that should be a public policy issue, not one that seeks to punish people. So my colleague Alistair Adamson, who is no longer at the organisation but is now training to be a barrister, he presented to the public protection, so it's the Public Safety Council sort of assembly part, and he presented the evidence and they rejected the PSPO. We have just had similar experience in Haringey, which is another part of London, so very similar PSPO, and again working in coalition with Liberty, which is the UK's equivalent of the ACLU in the US, and the Museum of Homelessness, which is a fabulous creative endeavour to really evidence the full lives that people lead who are unhoused, and how we must respect those lives. And so we came together and we are currently working to challenge the PSPO in Haringey. So from that, the challenge we have at Release is, I've just given you 3 local authorities. There's 329 local authorities in England and in Wales. Now, ASBOs and PSPOs ASBOs, the civil orders, don't apply to Scotland. Scotland doesn't have this legislation. We can't do this in 329 councils. That would be a full-time job for everybody, I think, at this conference, really. So what we've started to do, and this is where I'd love to learn from others on this, is we've started to map these local authorities. Like, where's the PSPOs? Is there a PSPO? When was it brought in? When's the renewal date? When are we expecting a consultation? What are the powers? And then looking at who can we engage on this. So local partners, national partners, the Green Party. As I said, there's been a local elections, a council. There's one coming up, I think, next week. But they've done really well. They're really passionate about challenging these things, so using them as allies in this space. And as well as the mapping, which we hope to be able to put online, is also to have resources so people can make the argument, so that they can say why this wouldn't work in their area. And there will be different arguments for different localities, so this will kind of be a live document. But I think beyond the kind of resourcing and building and mobilizing a response against this, we really need to think about solutions. And the picture there is our harm reduction hub in London, which we were very proud of, which was set up by our head of drugs, Sheila Soshenberg, and the team. And they have mobilized over 100 volunteers in the last year, and these volunteers are helping us with are helping us with the with this exercise. But I think this comes down to like spaces as well, because what we're seeing is an attack on people in public spaces. So not just in the UK, but in countries around the world. So solutions, and this is obvious to all of you, but like drug consumption rooms and cannabis social clubs, because young people are being targeted for smoking cannabis in public spaces because they don't have the private spaces to use. And so, cannabis cafes, we need to think about creating those spaces. The other thing, and it's a piece of work that we've just started as well, is around high tolerance housing. So, particularly people who are living in shelters and hostels, who are at risk of eviction for using drugs on the premises, trying to develop policies that support those shelters and hostels to permit drug use on the premises. And there's a handful of examples of that in the UK currently. And in one locality in Scotland, Simon community, they have introduced high tolerance housing after they had over 20 deaths in, I think, a 2-year period up in Glasgow. And really what it is like, it says to the individual, you can use drugs in your room. Let us know that you're doing that. We'll set up a plan with you. We'll check on you after a certain amount of time, and we'll administer naloxone if we need to, or give you support in another way. So I think it's about finding these solutions as well as attacking the policies. And so it's part of our wider strategy around decriminalising people who use drugs, because prohibition has tentacles. It's not just the criminal law, it's in every aspect of our lives. And so we need to see how we can remove those tentacles. I also really like octopuses. Thank you.
Thank you very much, Niamh. I can't help but wonder if some of these laws have kind of been, exported indirectly from the US. Like I'm thinking about, yeah, exactly. Like federal crack house laws from the 80s in the US, which, kind of have impacted the starting of drug consumption rooms in the US, which kind of links us back to our first speaker as well, Céline. So we're going to move on to our next speaker, so we have some time for Q&A at the end. And our final speaker is Sergio Perez. Sergio is a lawyer from EFIT University. He's worked in strategic litigation on human rights and territorial autonomy, and he's currently a researcher in the drug policy line at and I'm going to butcher this because I don't speak Spanish, is Unhoused, and his latest publication was on the constitutional obstacles to drug market regulation in Colombia. Thank you very much, Sergio.
Hi. Okay, thanks, Benjamin, for the presentation. I'm going to make my presentation in Spanish, so I will try to speak slowly. Soy Sergio Pérez, actualmente trabajo como investigador en la línea de política de drogas de justicia y mi presentación va a consistir en explicar cuál es la situación de criminalización del consumo de drogas en espacio público en Colombia. Y para esto creo que es importante partir del concepto de que no estamos en una situación de plena descriminalización de las conductas. Yo quiero insistir en esta presentación y en otros espacios en los que trabajamos en el concepto de criminalización administrativa, en la medida en que, aunque no se impongan penas privativas de la libertad para las personas que usan droga en el espacio público, sí existen unas medidas, como bien lo decía Niamh, de represión, digamos, administrativa, como multas y como comparendos, como lo conocemos en Colombia. Insisto en el concepto de criminalización administrativa porque comporta casi que la mayoría de las características de la criminalidad de una conducta, y hay un reproche jurídico contra una conducta. Normalmente ese reproche tiene una consecuencia, que en este caso son las multas, y lo más importante y lo que es muy preocupante en la situación colombiana es que este tipo de normas habilitan el contacto entre personas que usamos drogas y la policía. Y este contacto entre personas que usamos droga y la policía suele ser siempre un contacto hostil, que está, digamos, sesgado por tipos de origen de clase, raza, género, orientación sexual. Quisiera comentarles que en Colombia tenemos más de 30 años de despenalización del consumo de drogas, pero estos 30 años han sido difíciles en términos de cuál es la aceptación política y social a la descriminalización. Lo que hemos visto y lo que se puede analizar es, tenemos un Congreso que está en contra de estas medidas y ha tratado de hacer todo lo posible por revertir la descriminalización, y estamos ante unas cortes judiciales bastante garantistas para proteger los derechos de las personas que usamos drogas. Un ejemplo es que en el 2009 el Congreso de la República intentó volver a introducir las penas de cárcel para el uso de drogas en los espacios públicos en general, y ese mismo año la Corte Suprema de Justicia decidió ampliar lo que nosotros conocemos como los límites o los umbrales del uso de drogas para poder tener conceptos como la dosis de aprovisionamiento, que permitiría que las personas puedan cargar más de lo que la ley, digamos, permite. Con todo esto, el principal quiebre que ha tenido la despenalización en Colombia ha sido el uso de drogas en el espacio público. Y esto lo que nos ha traído es que los intentos de contrarreforma, los intentos de volver a instaurar sanciones administrativas, se han concentrado en decir, no voy a poner una sanción penal, voy a poner una sanción administrativa, y esto es diferente y no es tan grave, pero en realidad es muy grave porque se suelen, en Colombia al menos, aplicar sobre dos grupos que son muy vulnerables: es las personas que no tienen hogar o las personas que están en condiciones de marginalidad socioeconómica, y los jóvenes, que normalmente consumimos drogas en el espacio público, principalmente marihuana. Un poco la historia de cuál ha sido el devenir de la prohibición de consumo en espacio público en Colombia se posiciona a partir de 2016 que se expide un código de policía o de convivencia en el que se incluye más de 12 sanciones al porte o consumo de drogas, incluida una prohibición general de consumir todo tipo de sustancias, incluido el alcohol. Aquí se utilizó, digamos, contra esta norma el litigio estratégico y se demandó ante la Corte Constitucional de Colombia esta norma porque violaba con la Constitución política. La Corte en su momento reconoce que esta norma violaba la Constitución porque prohibía de manera general el consumo y no alentaba, digamos, a proteger la convivencia, porque no tenía ese propósito. Sin embargo, el Congreso de la República, 6 meses después, volvió a introducir estas mismas sanciones con un poco de diferencias. Una diferencia es que la norma ya no estaba para proteger la convivencia en el espacio público, sino más bien para proteger los derechos de los niños y de los menores de edad, lo cual nos sitúa en una discusión totalmente distinta. Otra diferencia muy importante es que pese a que llevamos más de 20 años de descriminalización del porte y del consumo de sustancias, el Congreso volvió a introducir una pena administrativa para el porte de drogas, lo cual no tiene sentido porque el porte de drogas no representaría ninguna afectación porque estamos ante una situación donde alguien está cargando una sustancia y punto. No hay ningún tipo de afectación. Lo que ocurrió con esto es que de nuevo se volvió a utilizar el litigio estratégico contra esta norma y lastimosamente he de reconocer que aquí tenemos que decir que hay que saber cuándo el litigio debe ir, hasta dónde deberíamos explotarlo y cuáles son los límites del litigio y en qué momento deberíamos no hacerlo. Y creo que la experiencia en colombiana nos enseña esto, porque en el 2023 se volvió a demandar este tipo de normas sobre el porte y consumo en el espacio público y el resultado es bastante difícil de entender, inclusive para nosotros los colombianos, porque la Corte, al analizar la norma, dice esto está inválido, esto está mal, esto no está acorde a la Constitución y de acuerdo a los derechos humanos. Sin embargo, como vamos a proteger los derechos de los menores de edad, vamos a mantener esta norma, vamos a seguirla, a mantener su vigencia y vamos a dejar que las autoridades locales definan en qué lugares aplican y no aplican ese tipo de restricciones. Lo que tenemos como resultado es que actualmente Colombia tiene más de 50 regulaciones sobre el consumo de drogas en el espacio público, las cuales suelen ser incluso contradictorias entre sí. Muchas de ellas, o la mayoría, son, digamos, inválidas constitucionalmente, no tienen un fundamento jurídico adecuado, porque incluso criminalizan el porte de drogas cuando no debería ser una conducta a criminalizar. Y hay un gran problema con la dispersión, digamos, de este tipo de regulaciones a nivel local, y es que en Colombia es mucho más fácil demandar una ley de la República y lograr su invalidez a demandar un acuerdo municipal y lograr la invalidez del acuerdo municipal. Es absurdo, pero los procesos de litigio ante la Corte Constitucional son fáciles, son expeditos, duran un año y medio, mientras un litigio a nivel local puede durar 2, 3, 4 años. Y lo que hemos visto durante este tiempo que surgieron las regulaciones locales es que incluso bajo una misma demanda con los mismos argumentos, tenemos 2 decisiones judiciales totalmente distintas. Entonces tenemos una ciudad, ejemplo, Pereira, y una ciudad, Cali. En ambas ciudades se presentaron los mismos argumentos, pero la respuesta judicial fue totalmente distinta. Y esto es uno de los riesgos, y esto tal vez como la gran dificultad que tenemos en no haber reconocido a su tiempo que estábamos en el límite del litigio. Aquí quisiera ahondar un poco en que es muy importante para nosotros en las sentencias de la Corte Constitucional el contenido que trajo las directrices internacionales sobre política de drogas y derechos humanos, especialmente el derecho a la participación efectiva. Y eso es tal vez uno de los argumentos que más hemos utilizado en contra de estas regulaciones, porque no se están construyendo las regulaciones con las personas afectadas por la regulación. No se utiliza o no se tienen en cuenta a las personas que usan drogas en la construcción de estas regulaciones, lo cual básicamente pierde todo sentido dentro de un Estado democrático. Y también lo que vemos es que finalmente la prohibición general de consumo de drogas en espacio público lo que nos enfrenta es a una exclusión de las personas a la ciudadanía, porque finalmente el espacio público es el lugar en donde se ejerce la ciudadanía completamente. Todos somos seres humanos en la privacidad, pero cuando somos en el espacio público somos ciudadanos. Y aquí quiero ahondar un poco sobre cuáles han sido los principales impactos de estas regulaciones. Como bien lo decía Niamh, el principal impacto es hacia las personas que no tienen hogar o que están en condiciones de marginalidad socioeconómica. Esto representa un gran problema en la medida en que las multas lo que hacen es inhabilitar a esta persona para que pueda luego conseguir un trabajo, porque normalmente cuando se aplica un trabajo se pide ese tipo de, como de historial legal. Lo segundo es que habilitan el acoso policial hacia las personas que usan drogas en los espacios públicos, sobre todo si son personas pobres, marginalizadas. Y lo tercero es que finalmente lo que hacen es que el Estado en realidad se concentre en sus deberes y se concentra en realidad en la persecución del uso de drogas cuando tiene prioridades más importantes en términos de seguridad. Y el otro grupo poblacional importante sobre el consumo de drogas en Colombia somos los jóvenes, quienes normalmente en el espacio público se consume licor o cannabis, y aquí, digamos, ha sido más un asunto no de condiciones de vida en las que no se pueda consumir en privado, sino más bien un asunto cultural. Es muy común el consumo de licor en Colombia en el espacio público, hace parte de nuestra idiosincrasia. En el 2019 el Código Policial lo intentó prohibir y en parte esa norma se declaró inválida por eso. Sin embargo, lo que está haciendo la prohibición del consumo de drogas en el espacio público con los jóvenes es de alguna manera señalarlos como target, como de alguna manera los está poniendo a disposición de la policía y a la arbitrariedad completa de la fuerza. Aquí quisiera, digamos, ahondar en tres aspectos importantes. Como bien lo decía, las multas que se imponen por consumo de drogas en el espacio público son multas bastante altas, pueden ser hasta $300 por consumo en espacio público. Hay un impacto económico muy fuerte, en especial de las personas que no tienen medios de vida adecuados para subsistir. Hay un impacto laboral, no se puede contratar con el Estado, no se puede acceder a ciertos trabajos cuando te piden la experiencia, digamos, de tu historial con la policía. Y finalmente hay un asunto de acceso a la justicia. No es fácil interponer un recurso judicial en contra de este tipo de multas porque los procedimientos suelen ser un poco arbitrarios, no hay una forma, no estamos ante un procedimiento judicial con todas las garantías, es un procedimiento en el que se aplica lo que el policía quiere aplicar. Esto nos lleva a que en ocasiones las personas lo único que hacen es aceptar el comparendo, pero nunca lo van a pagar. Se van a quedar siempre con la sanción registrada y cuando en el momento en el que tengan que acceder a algún trabajo o algún empleo con el Estado, pues tienen la limitación. Hablando de cuáles serían las soluciones para esto por fuera del litigio, cuando ya reconocimos que el litigio es una vía agotada, estoy de acuerdo con Niamh en que una de las soluciones es las salas de consumo supervisado. Cuando estamos ante consumos, digamos, por vía inyectada o no, y tenemos digamos, aquí voy a hacer un acto de reconocimiento y tenemos una gran limitación en Colombia y en el sur global sobre cuáles son nuestras respuestas de reducción de riesgos y daños para cocaína, fumables y otro tipo de sustancias que no son heroína. Sin embargo, aquí yo creo que hay un punto importante de resaltar y es que las salas de consumo supervisado son apenas el primer paso para que se garanticen los derechos de las personas que están en condición de marginalidad, porque creo que es ahí donde está el punto y es lo que debería importarle al Estado es garantizar el acceso a derechos de estas personas, no su condición de consumo en absoluto. Y la segunda solución, como bien decía Niamh, son los clubes canábicos o cafés en los que los jóvenes puedan consumir. Y aquí yo tengo una pequeña crítica y es que finalmente creo que estos clubes son clave para un poco como sacar el consumo del espacio público, pero no son la solución final porque tienen ciertas barreras de acceso. Entonces, los jóvenes que quieren fumar marihuana en los parques lo hacen porque no tienen otros más recursos y puede que ir a un café cueste dinero y eso es una barrera de acceso. En un punto, y sinceramente yo creo que el consumo en el espacio público no debería ni siquiera pensarse en cómo acabarlo, sino más bien cómo vamos a regular una conducta que está inherentemente relacionada con el espacio público y que va a seguir estando en el espacio público. Y aquí lo importante es cuando de verdad el consumo representa una afectación a los derechos de otros y debería ser una preocupación para el Estado, y cuando no, porque por ejemplo, y es una cosa que decíamos, el consumo de marihuana en un parque a las 10 de la noche no representa ninguna violación para un menor de edad. Si un menor de edad está a las 10 de la noche en el parque, es porque ese menor de edad tiene problemas con su familia y con sus propios derechos. Y finalmente, pues, quería agradecerles por la paciencia, por el espacio, y no sé si alguien tiene una pregunta.
Thank you very much, Sergio. I want to applaud you for keeping within time as well. Very much appreciated. I can't help but draw parallels between what you were speaking about, the criminalization of poverty and homelessness in Colombia, and what Niamh spoke about earlier about what's happening in England and Wales, what I've been seeing happen in the US for quite some time. I'd like to open the floor for questions. We do have a little bit of time. We have about 28 minutes. When I hand you the mic, can you please state your name, your organization, and who on the panel the question is directed at, or if it's the entire panel? And I believe Niamh also has some questions for the audience. So maybe if we want, do you want to start by, let's make this a two-way street. Let's start a little bit of dialogue going on rather than just kind of a general Q&A.
It was just a general call for advice, really. But I think, it speaks to what you were talking about, Benji, and the fact that, we've got this long history of the US using different laws to control populations. And it comes back to the fact, we're only controlling, not all people who use drugs are affected similarly by drug prohibition. For people who have, the protective factors of class, race, and, economic status, drugs are largely decriminalized for them. So it's thinking about what in your spaces are happening that are similar, that doesn't fall directly necessarily within criminalization, but this kind of ancillary set of laws that can harm people's lives in such a dramatic way, like removing their house, removing their children, and work that you've all done locally to try and challenge that through strategic litigation, through community legal services, through community advocacy services, just, having that conversation, really.
Can you pass me that mic?
I can't get it to work. Otherwise, we can wrap up early and everybody can have
Hello? Yeah, okay. This mic's on. Do you have any questions or answers to Niamh's kind of call?
Hi, I'm Brittany Maple. I'm the Executive Director of Matsaqui Abbotsford Impact Society in Abbotsford, BC, Canada. And we have, since last June, there was a large decampment of our folks. And so we've been involved in litigation against the City of Abbotsford, and now the BC Attorney General is coming at us for an appeal. And we don't have the benefit of lawyers, so I've been self-rep litigating this entire thing without any legal education, which has turned into a civil court case, which set an incredible precedent for an injunction that stopped the city from, because the change was that in the context of the toxic drug poisoning crisis, this is a new novel case. And so I think for us, it's just like the civil litigation system, all of it, it's hugely inaccessible for people. And we, to stop a decampment, had to initiate a judicial review of a trespass notice, and I had to file that case within 2 hours. And so it's just something that people can do, though. People can do it, and sometimes we just have to. It was a bit of a disaster, right? And we had to go back, but we still haven't been able to secure lawyers to do it. So that's
and
kind
we
of.
have connected with some could help you because in BC you have Pivot. I mean, they don't work with you or they
Yeah,
don't.
Pivot is
Yeah.
the only human
The only
rights.
one. True.
Yeah, and they're overwhelmed.
Of course, yeah.
Right.
So that's the point, that you don't have access to others that can join and support and
Yeah.
yeah, it's true. After
Yeah,
you
and
are
we're also involved in the decriminalization,
Yeah.
recriminalization against the federal government, our organization as well. So we have lawyers on that front.
okay.
So you win some, you lose some.
If you wouldn't mind, what I'd love to do is maybe talk to you about having something on talking drugs around that. Because I think, again, when we share these stories, we empower each other to do this work. And actually, like different legal systems, obviously.
Yeah.
But nonetheless, showing that someone can navigate this and then thinking about how do we map that in a way that shares that resource both locally and then in other jurisdictions.
Yeah, and that's what we've been doing so far on a small scale within BC, right, is empowering other organizations. Really, like we set up a giant encampment of 50 plus tents on City Hall's property, really, to just get in their faces. But that's been since June 29th of last year, so, and we're still standing.
And it also speaks to, like, sorry to interrupt, I know I'm not on the panel, but it also speaks to the need to kind of bring in a whole new generation of lawyers. And like I've worked on projects both in my home city of Sydney, and you know what we're trying to do with my new organization in New York is to kind of, you know, teach for first year law students about these issues so we can bring on new advocates for the, you know, next generation.
I liked it so much I wrote my LSAT in January.
My name is Justine. I am a member of the Harm Reduction Advocacy Collective, coming out of Toronto, Canada. I'm also an immigrant in Canada. This is my homeland. I'm back here for the first time in 18 years since leaving as a protected person. Right now in Toronto, things are really hot in the sense of we have a conservative government that a bill passed that essentially shut down all of 12 over 17 supervised consumption sites, otherwise DCRs. In Ontario, we are currently in a charter challenge. We did get an injunction, but the problem with the injunction was that it didn't actually recognize. It was presented as a zoning law, so wanting to like keep it out of specific areas that like minorities would be affected by, so daycares, things of that, schools. So there's an injunction there, but now the judge is coming forth and saying there was a whole nother application in which they said that in order to support people who were using drugs and who were marginalized, particularly people who were unhoused, they were going to operate something called the Heart Hubs, which essentially offered, and every agency that applied for this funding had to give up the ability to distribute any type of harm reduction supplies and provide any type of harm reduction support, in the promise that there would be housing, that there would be additional healthcare, but in the healthcare there's no like OAT that would be accessible. Safe Supply is now completely underfunded, and so it's under like every physician to be able to choose whether they want to put their license on the line. Prior to this happening, there was also an introduction of a different bill, which particularly focused around the Safer Communities Act. It was specifically about making sure that no encampments really continue to exist and be in the public eye. That did not pass, but now with the Conservative government winning just under past provincial election, now that's back on the table. And it's really hard because I think much to what Sergio was saying, it's this chosen, it's the government choosing who is a community member, right? And who is worth of safety. And this is the continuum that, like, it's really surprising to be sitting here and seeing that this is not just like an issue that I have been paying such close attention to in the province, but rather it's an actual international issue that keeps happening. And so I think really in what we are trying to do, and so much of, like, I don't know if folks were sitting in the preliminary this morning, but that ending piece was really touching for me, where it's like we have to connect, we have to build coalitions. We are part, the HAC Toronto is part of a larger Ontario coalition of people who are just like mobilizing and making actions against the government. Because now even at this point in time, there's now talks about the city actually removing our right and zoning where we can protest and where we can't. This would include things such as City Hall and Queen's Park, which is our provincial house. And so this is it, right? They're trying to shut every possible door that we can to push back, and in it really choosing who is considered safe and what kind of safety we really care for. So I think really in all of it is we have to stand up in solidarity. We really have to educate ourselves. We have to educate the people around us, and we have to do that really hard work to continue to build community, because without community, what do we have? We've got nothing, and all that we really need as humans is connection, and that's how we do it.
Sorry. Yeah. Hi, my name's Grace. I'm from Toronto. I actually am a law student right now. And I work at some safe injection sites in Toronto. My question, I guess, is actually for Céline, but I think it probably applies to everybody. I'm really curious about when different levels of government, like for example, you said your federal government has said harm reduction is legal, but then, you know, municipalities are making it like functionally impossible to actually do. Are there ways that those kind of inconsistencies in the position and jurisdiction can be used like to your advantage? Like, you know, in Canada, I think of like constitutional principles around, you know, federal paramountcy and you know, for example, like in Canada for abortion, provinces were making it functionally impossible to get an abortion through regulating how hospitals work. And, you know, they said that wasn't right. And that inconsistent like position was used to eventually make sure that abortion was accessible. So yeah, I was just curious about how those inconsistencies between your federal government, municipalities, or I guess not province, I'm not sure what France has actually, how those could actually, yeah, maybe, what does that look like to see that kind of inconsistency? And is there anything legally to be done about it?
Actually, the first litigation for the sustainability of drug consumption room is also based on the responsibility of the states, you know, which is actually inconsistent, because with the 2004 law, I mean public health law, which recognize harm reduction, the state has to provide sufficient means, I mean, and to be sure that drug users, especially the ones who are more marginalized and in the street, have access to health, right, you know, and so not to make obstacles to drug consumption room, to the opening of drug consumption room. It's like, it's not, I mean, the state is not doing what it's supposed to do, you know? So you can really point that, and it's based on that we said, okay, you have to sustain drug consumption room because you have the obligation actually to do it. And it's because it's part of giving, I mean, access to health and social services, because as you said, this is the way to answer, I mean, the big question of public space and how to deal with public space, but it's and to give security to everybody, to the drug user, to the general population. So we point that, but after maybe there is something more than a lawyer could answer you, maybe more in depth than me, but probably you can.
I can do. I don't practice law anymore. I should say that, otherwise I'll get into trouble. So, firstly, to my Canadian colleagues in the room, good luck. We are with you. We are worried too, but you know, it does help having a constitution. So we're in the UK. We don't actually have a constitution. So I mean that's a challenge in itself. But I think, you know, using constitutional arguments is an incredibly important tool. And in fact, I'm looking at Daniel. We were at a pre-conference meeting that Sergio and others from De Justicia led on decriminalisation around the world. And most of the countries, and at this stage we say, what would we say, 40 roughly countries, have adopted decriminalisation, and the vast majority of those have been achieved through constitutional court challenges. And I think there is something particularly useful about that because it prevents rollback. It's not perfect. Some countries there has been rollback, but that jurisprudence gives you some tool against the state, that the state has to act. But in the absence of a constitution, and coming from a country that does not have one of those that we can point to directly, you mean judicial reviews, like you're using in the administrative law, where the local municipality, the local authority has diverted from national laws and procedures. So I think there is a way to do it. But I think it comes back to Benji's point. We need more lawyers, law students, but we also need to not hold the law as a specialism. Like, the law is meant to be for community. It is purposefully designed this way to exclude community. So actually, I think some of it is exactly like you've done, Brittany, is like learn, like do it. And like, it's our job maybe as lawyers, although we're all busy trying to, like, I'm not practicing, but my team of lawyers who are amazing, to, like, they're doing the work. Sometimes it's just hard. So maybe working out how we build the resources to give community that power, because that's really where strength will come from.
Voy a responder en español. Yo creo que depende mucho del modelo de Estado en el que nos encontremos. Colombia es un Estado unitario, no es un Estado federal, y aún así se les dieron las competencias a las autoridades locales para regular, lo cual es bastante particular en términos de seguridad y en términos de uso de drogas en espacio público. La principal diferencia es que los argumentos constitucionales funcionan a nivel nacional porque hay una gran trayectoria por parte de la Corte Constitucional de asegurar que se cumpla con la Constitución, pero la tradición judicial menor de los pequeños jueces es totalmente distinta. El acercamiento del juez local siempre suele ser un acercamiento muy de la preocupación del día, desde lo, digamos, inclusive desde el prejuicio. Entonces, muchos jueces han respondido a las demandas sobre estas regulaciones de consumo en espacio público, argumentando que están adecuadas porque protegen la seguridad ciudadana, lo cual no es ni siquiera el propósito de la norma. Entonces creo que hay una total como distinción entre el argumento nacional y como la importancia de asegurar la Constitución, y luego cuando estamos en un nivel mucho más pequeño, la Constitución pasa a dejar de importar, lo cual es absurdo en un país que tenemos Constitución.
I think we've got time for one more. Do we have any more questions? Comments? Anything? You've got one? Yep. Just here, we just have a microphone. And please introduce yourself. Thank you.
My name is Phil Broyles, and I run a treatment program in Portland, Oregon. It's called Teros Intervention and Counseling. And you mentioned that what happened there earlier. And the way I see it, there was a coalition of rich people who owned real estate in the downtown area, and they had this team of people that were on social media, and they were spreading all kinds of lies and sensationalizing things, and it took them about $7 million to convince the legislature to overturn the decriminalization. And it was so frustrating. And my own representative, who's helping me get a law passed for something else, he voted for the other lie. He said it's the least of, the worst possible consequences. They created a new category of misdemeanor for drug possession, and they even had a part of the, and I don't know if it went through or not, but part of the law that said if you got caught with drugs within 500 feet of a drug treatment center, it was a harsher penalty. And so I don't know. I just don't know what to do when people with money can do stuff like that, and it's because it's a local municipality mostly. It's a small state. It's got 4 million people in the whole state. So I haven't been able to find any attorneys to do anything for me because they're too busy making money to stop and help, and it's really discouraging. So I don't know if you have any advice about that or not. Anybody?
Oregon breaks my heart. Yeah, it was such, like, decrim in Oregon was a success. And we have to constantly tell that story, you know. Decrim does one thing, two things. It reduces arrests and it creates an environment that people can access services. Right. And these things were happening. Mm-hmm. And I think the fact that the law came in when the pandemic hit, and that the second part, so it wasn't just the decrim, and for people who don't know about the second part of the Oregon law, do you want to tell them rather than me Oregon explain?
Which part are you
the
talking?
tax.
Oh, the tax. Oh,
yeah.
Yes, it was the marijuana sales tax. Yeah. That's how they were going to fund it.
Yeah. So the marijuana sales tax, they expected when cannabis was first legalized in 2016.
Something like
that. Yeah, I think they expected like 40 million in taxation, and in the end it was 150 million.
Wow.
And so like this 100 million was like, what do we do with it? And as part of the Decrim initiative, which was led by amazing people in Oregon and the Drug Policy Alliance, was like, let's use this money to invest in housing, to invest in like, let's build a social safety net. But the idea that you build a social safety net in the other side would have 50 to 100 years on their game. Exactly. We had 2 years and a pandemic. You know, it was ridiculous. And I think this is a bigger conversation about media and influence and money in this space, like the right-wing attack on harm reduction and how harm reduction has become a culture war issue in a way that I don't think it was 10 years ago. Yeah. And how we navigate that. Like, I think these are big questions that we're all sort of wrangling with. And I don't have an answer for it. You know, I think some of it is going local again, like doing that. But, you know, I don't have an answer to it. But it is a conversation that's certainly happening at an international level as well. You know, so it's really hard at the minute. And what frustrates me about those who criticize harm reduction and who criticize decriminalisation, they're not actually doing the work. All they're doing is going online and bitching about us. Do you know what I mean? They have the time to waste on that. We don't have the time, you know? So, sorry, that's not helpful.
Well, one of the biggest contributors is this guy named Phil Knight, who owns the Portland Trailblazers. And I mean, if he put a fraction of the money towards treatment services and other resources, rather than trying to fight a law that's going to help people. But they did the whole, you know, criminalize homelessness and public drug use, and they latched onto that. And the law actually gives the police the ability to arrest you for 48 hours, which is long enough for them to sweep your home off the streets, and then you don't have any resources at all. And the only way you get, they call it deflected to this treatment, it's a disgusting word, I hate it too, is if they were just arrested for drug use. And that's it. And they don't have any other warrants, and they don't have to go to jail for any amount of time. The whole thing is just disgusting. I'm sorry.
I mean, the other thing that was interesting during that period was the reportage by the New York Times and the Washington Post, which was linking Oregon to Portugal and presenting Portugal as a failed experiment. Right. So they did these huge pieces where they had, like, I think the mayor of Porto, who's a bit of a dickhead anyway, sorry, I'm sorry. He's honestly, sorry, this is oops. But it was one politician who was just, you know, critiquing the decrim piece. So this gets published in these like major newspapers, and like DPA, others were like ringing them going, this is not factually correct, because at the time they were presenting that in the US media, Portugal was actually advancing decrim. It was strengthening the model. Not only were they adding synthetic opioids to the list of drugs that were decriminalized, they were also adapting their approach to thresholds. So thresholds had been, you're allowed 10 days worth of supply in Portugal. And in 2006, a constitutional court, this is a bad decision, said that if you were caught above the threshold, that it was a criminal possession. And actually in 2023, the Portuguese government Parliament went, no, let's change that. That's not right, because if someone's caught in possession, regardless of the amount, if it's for personal use, they should be benefiting from the system. So this was happening in tandem to like two of the major newspapers in the world totally misrepresenting the facts. And I do think something is around the money on this, like who's influencing that. So yeah, sorry.
Well, the real estate in downtown Portland was 30% lower than what it had been previously to the pandemic, because their prices are too damn high to begin with, and nobody wants to open a business down there, so they just scapegoated the people that were on the streets. And so.
Any quick, very short comments? We have about 1.5 minutes. Okay, before I ask you to give you a round of applause for all our panelists today, I'm just going to do a shameless plug for a session at 4:30. I'm actually speaking on a drug policy panel. It's on codifying international law, like some soft law resolutions into hard law. If you're interested in it, it's in 3P, but that's just a shameless plug for that. But can we please put our hands together for all our amazing panelists today? Yeah.